Welcome, everybody, to the wonderful group assembled here for this evening's virtual Small Business Legal Academy. My name is Aliza Shadovsky. I am the Director of Pro Bono Programs for Tzedeck Legal Services and the Acting Director of our Small Business Development Project. Today's program is the result of our partnership with County Supervisor Holly Mitchell and her fabulous workforce development and economic development teams, along with a committed and skilled group of pro bono attorneys from the law firm of Jenner and Black and the legal department of Fox. We've joined together to bring you a program highlighting the key legal information and services for small business communities of LA County District 2, and to tell you about free resources that we hope will help you and your small businesses to continue to thrive and grow. I am absolutely delighted to have the honor to introduce Supervisor Mitchell, who, after serving for 10 years in the California State Assembly and Senate, was elected supervisor just last year and has already established herself as an energetic advocate for and champion of workers and businesses in the district and county. Her focus on building and strengthening community partnerships and systems to help businesses and residents of LA has been instrumental in our bringing this Small Business Legal Academy to you. Supervisor Mitchell, we're thrilled that you've joined us this evening, and I yield the virtual floor to you.
Alisa, thank you so much, and it's great to see everyone. And I'm going to be very brief because you didn't come to hear me, you came to get really critical legal advice, and I'm thrilled to have had the partnership. And let me just say that, my history with Tzedeck goes back quite some time, when I was an advocate for the Western Center on Law and Poverty. And then we partnered on many occasions when I was the CEO of Crystal Stairs and providing support to our childcare sector. So thank you so much. And thanks to the skilled attorneys of Fox and Jenner and Block for bringing your expertise to the table tonight. So why are we here? Well, we're here because we know that small businesses are the lifeline of our economy. They're the top employers, quite frankly, in my district across California. And we know the resiliency you've had to exhibit to survive, like all of us this past year. And we want to make sure, I want to make sure that the county is stepping up to the plate to do all that we can to support your survival and your growth. We need your sector to thrive. You probably know these statistics better than I. 93% of businesses have 20 employees or fewer. And according to the LA Economic Development Corporation, 62% of businesses in the county have less than 2 months cash on hand. These numbers only confirm the need for resources and trainings just like this, particularly when we are guesstimating, and I'm sure the number changes every day, in the neighborhood of 15,000 businesses that have already permanently closed as a result of this dual pandemic, both public health and economic. And I'm deeply concerned that as we continue to fight the current version of the virus, that many more may continue to suffer. So as we talk about what recovery looks like for LA County, as we talk about an equity lens on recovery, as we talk about what kinds of support small businesses need to get through the end of the pandemic and into recovery, that's what we'll be talking about today. A couple of quick things that I've done since joining the Board of Supervisors to aid the sector. In June, I authored a motion that passed unanimously to further extend anti-displacement protections to small businesses and to provide commercial lease assistance. The motion also asked the county to find funds for a $10 million small business rent relief fund to help businesses keep their doors open. We'll keep you informed as the commercial lease assistance program is launched in the coming weeks. I'm very excited about that. As of now, the county's commercial eviction moratorium protects you from being evicted due to non-payment of rent until the end of September 30th. If you want more information on the county's eviction moratorium program, please visit dcba.lacounty.gov/no evictions. And I'll ask Carolyn or someone from my team to please put that in chat. As I'm sure you know, the federal government passed the American Rescue Plan Act to give out funds to local governments to assist with the recovery. Just yesterday, our board approved over $70 million in American Rescue Plan funding to go directly to small businesses, nonprofits, and community-based organizations. In the coming months, we'll start to offer grants, microloans, lease assistance, and technical assistance. So I encourage you all to stay up to date on the rollout. This is a dynamic process. As quickly as we can draw down federal and state dollars, we're going to do all that we can to get it on the street as quickly as possible. And our state agencies like DCBA have done a great job thus far of really doing that. I ask that you stay connected with my office. Our website, our website is mitchell.lacounty.gov, mitchell.lacounty.gov. And we work really hard to make sure that we can keep it up to date as quickly as possible. So you know that the actions that your Board of Supervisors have taken on your behalf and the resources we're working morning, noon, and night to bring to the small business sector and small employers across LA County. So Lisa, again, thank you for the gracious introduction and for the partnership, and I'll kick it back to you.
Wonderful. Thank you so much, Supervisor, for your words, your actions, and all the resources that you've pointed out. So next I'm going to introduce Bria Stevens. She is the Tzedeck Small Business Fellow. She's going to give the small businesses on the line some information about the free legal services and resources that are available through Tzedeck. And then she's going to take the time to introduce you to our terrific presenters tonight so that we can get right into the program. Bria?
Thank you, Elisa. Just taking 1 second to share my screen. Okay, so good evening, everyone. My name is Bria Stevens. I'm the Small Business Fellow with Tzedeck Small Business Development Program. I work along with Elisa Shadowski, who is our acting director, and overseeing all aspects of our program. So just for a little bit about Tzedeck generally, we're a nonprofit law firm and we provide our services for free to individuals in the LA County area. We provide these services regardless of anyone's race, religion, ethnicity, or immigration status. So then just to dive a little bit deeper into what we do with the Small Business Development Project. So we're designed to help low to moderate income entrepreneurs. We help specifically with transactional type issues. So things like litigation, things that involve going to court, we do not assist with. But we do this in a variety of ways. So one way is through doing presentations and workshops. We focus them on transactional topics, and they're very educational and helpful and meant to give legal information. Another aspect that in a way that we help small business owners, and I'll describe this in a little bit more detail too, is that we offer direct client representation. So we have an application, and I will put the link to the application in the chat, but we have an application that you can use to apply for services. And through there, we can get you some direct assistance through our vast network of pro bono volunteers that we work with. And then another way that we help is through small business legal academies, so things like this. And what these legal academies do is they kind of combine both of those aspects of our program to give educational presentations on topics that are helpful to small business owners, but then also to offer some semblance of an intake or of a informational call to kind of go over some legal issues. And then in 2020, with the onslaught of the pandemic, we've been able to really expand our services, really been able to offer more educational webinars, been able to expand our network of pro bono partners that we can work with in an effort to meet the demand of the issues that small business owners face. So this was called the LA Represents Project. And as you can see here, we were able to grow our program exponentially and just the services that we are able to offer. So here you see a list of the different issues that we can offer assistance with. Again, all of them are transactional in nature. I really wanted to highlight the commercial leasing issue that we offer, because that's a especially important topic that's come up a lot with small business owners during the pandemic. We do offer services for those types of issues, specifically with commercial lease negotiations. Again, just want to emphasize that we help with transactional issues, but again, that is a very big issue that we've been offering our assistance for. And then as you can see, we also help with other transactional issues, things like IP, entity formation, contracts, some of the things that we'll be talking about today during the presentation, but really have a wide variety of the different type of issues that we can assist with. And again, this is just a summary of what we do as far as webinar and workshops, direct legal services, and our small business legal academies. We also have helpful resources such as FAQs and guides on topics as well. So if you're looking for quick information or just looking for some guidance generally on a topic, we have a resource page, and that's something that I'll also be putting in the chat as well. So then again, we have the free presentations, the FAQs and COVID guides that we offer assistance with, but I did want to touch on our direct representation that we offer. So that is just a part of our program where we can work with small business owners and place them with pro bono volunteers who are willing to take on the case. But we do have some eligibility requirements that are associated with that. So just wanted to highlight some of those. We look at personal income, and we also look at business profits and sell as well. Again, we assist with transactional issues, and then importantly, we help with for-profit businesses that are operating in LA County. So if you're a nonprofit business, we cannot offer assistance. But when I say we cannot offer assistance, that doesn't mean that we don't have resources for you. Again, we have those webinars that we put on. We are happy to share the guides and the FAQs that we have. And we'll also have information to other organizations and other partners that we work with that can be of assistance. And that's the link to our application. No need to try to write it down. I'm going to be putting that information in the chat, as well as the link right here to our resource page. So if you do have questions, feel free to email me. My email is here, bstevens@Tzedeck. I'll be putting that in the chat as well. So if you do have questions, generally feel free to shoot me an email. And with that, I'm going to stop sharing my screen. And right before I introduce the amazing attorneys who are going to be presenting on entity formation, I just want to highlight some things. So the presentations are going to be around 20 minutes, and we're saving the questions portion for the end of the presentation. So feel free to put your questions in the chat, and then we'll be able to answer those questions then. And so with that, I am happy to introduce Chris Lindsay, Kai Dhaliwal, and Christian Jackson, who are going to discuss entity formation. We're very happy to have you guys here, and I'm grateful that you're lending your time. So with that, I'll turn it over to you guys to get it started.
All right, Bria, thank you very much. And Chris, I think you were going to run our slides for us.
Yes.
Thank you. Everyone, we're just thrilled to be able to kind of hopefully be able to help you guys a little bit. The three of us, we're going to talk about business entities that you would use for operating your business. Just kind of, you go jump ahead a couple slides for us, get to the overview page. Yeah, we're going to talk about the different kinds of legal entities, some of the key elements of each one, and some of the steps, like the actual tangible steps that you need to do in using these entities. You can jump ahead another couple slides for me, Chris. All right, so these are the types of legal entities that we're going to talk about. And before we kind of address them individually, the way I like to think of it is each of these entities have certain pros and cons based on some factors you should think about when you're choosing what kind of entity you want. The first factor we should think about is liability. So obviously one of the goals of your business is you want to make money, whether to support yourselves, fund other objectives you may have. And in the course of running your business, you want money coming in, but there's always the danger of creating liability. And the choice of entity can affect how liability arising from your business is handled. So this could be the difference between my business just went bankrupt versus I personally went bankrupt. So absent consideration, if something goes wrong in the course of your business, someone gets injured, there's a lawsuit, you as the business owner might not just be at risk of losing your business, but your wealth outside the business, your home, your savings. But there are ways to protect against that. We're going to address that when we talk about different entities. Another factor to think of is kind of how difficult is it to be operating this type of an entity? Depending on the entity, there's different requirements. At its most easiest, you just start doing business. You create a lemonade stand. The more complicated businesses require more infrastructure. At the highest level, You have public companies, they have boards of directors, articles of incorporation, bylaws, quarterly and yearly disclosure obligations, et cetera, et cetera, et cetera. Regardless of the entity choice, there may be other concerns about state law licensing requirements. So just in terms of the focus about what we're talking about here, it's mostly about the requirements that you have to observe specifically required to that entity. Another element we ought to think about is kind of the allocations of rights and responsibilities between owners. If it's just you running a business, it's very simple. However, if you have investors, if you have partners involved, and that can be either a partner in the formal sense that we'll discuss or just other people who are helping you in the business, you might want to have a chance to figure out how you're going to determine who does what, who's responsible for what, and who has what powers. And then finally, there's taxes. Depending on what entity you choose for your business, there can be different tax consequences. Kind of viewing it from a high level, there is either pass-through taxation, which means when your business earns money, it's like you earn that money. Or on the other hand, there can be where the business can be treated as an entity, as its own entity for tax purposes. And you will hear conversations about that where these companies are going offshore to avoid taxes. That's when you have a business itself that has its own tax personality. It will be taxed separately. So in that case, those companies are going to pay taxes on what they earn. And then you as the owner, when you receive money from that business, you would also have taxes, whether you're receiving that money as compensation, you're an employee of the company and you're receiving a salary, whether that company is, the business is distributing you money as a dividend, as a distribution, you would also pay taxes when you finally have, get the money in your own pocket. Taxes are complicated and they're not really the subject of this presentation beyond us just briefly using them to highlight the differences between the entities. If we can go ahead another 2 slides and we'll get to the first entity we're going to talk about. So the first entity is the sole proprietorship. This is basically just a person doing business. If you didn't do anything to set up an entity and you just, mixed your lemonade and went out on the corner, you're a sole proprietorship. It's where you're doing it by yourself. You can essentially, you can fall into a sole proprietorship. It's the default. With respect to liability, if something goes wrong, if there's a liability, it's on you directly. So this is a simple point, but I would probably say this might be the most important thing I'll say in this presentation, is that if you don't take the time to set up a business, you're going to be a sole proprietorship. And if someone is injured in the course of interacting with your business, they won't just have recourse against the money that business might be earning, but they could have recourse against all of your assets as well. That's obviously a downside of sole proprietorship. On the plus side, it's very easy to do. There's not a lot that needs to be done. There might be some things that Chris later on will mention just in terms of kind of doing business. But in terms of creating the entity, you don't need to do it because it's the default. Tax-wise, it's as if you earn the money. All right, so I kind of went through the second slide too. So the next one we're going to talk about is general partnerships. And a general partnership is similar to a sole proprietorship, but where there are 2 or more owners. So if me and my best friend, we're the ones running our lemonade stand, we've kind of fallen into a general partnership. For liability, it's similar to the sole proprietorship. Now both people are liable if something goes wrong. And if your partner, and so that's the same, but now that you've got another individual that you're working with, you lose a little bit of the control, right? So if they're the ones who create the liability, it might not just hit them. If the liability is big enough, it can hit you as well. So if your partner creates a business liability, then your assets can be liable. In terms of burdensome difficulty, this can also be very easy. It can get a little more complicated if you want to start addressing some of the things that we were just talking about. So perhaps you want to allocate the rights and responsibilities of your partnership. So in that case, you're going to you would put together an agreement with your partner to say, all right, I'll be responsible for this. You can be responsible for that. It won't necessarily help you in the liability, issue if the liability is great enough, but it could help you. And in that, you can also kind of determine who owns how much of the company, so that when we get to the final point, which is taxation, it also is passed through taxation. So the money earned by your business won't be taxed at the business level. Instead, it'll come to you and your partner, and it'll be allocated amongst you and your partner to the extent that you guys have agreed on specific allocations for that. All right, the next one, and I'm not going to take too long to go over the next form, which is the limited partnership. And that is a more kind of intentional entity there. A limited partnership is essentially a general partnership controlling the business with all of the upsides and downsides of the general partnership, including if you're the general partner, while you will be conducting the business, you're also going to be liable for the potential liabilities of the business. But what it allows you to do is have limited partners. And those limited partners are going to be passive. They're probably going to be investors in your business. And what they will be able to do is be limited from that liability that is otherwise on the general partner. Again, taxation, because it's a partnership, is passed through. So there's not going to be taxation at the upper level. In terms of burdensome and difficulty, it's going to be more complicated. You're going to need to have a specific agreement that sets forth the rights of the limited partners and allocates them. But it is it's definitely an option. If you're considering doing something along the lines of a limited partnership, you may also want to consider some of the other entity options that my colleague Christian will now discuss with you.
Okay. So I went to law school in New York, and I always loved analogies, and I love stories. So to help kind of describe some of the differences here and what's important to think about, there was a case I remember. If anyone's familiar with New York, we have taxi cabs going all over the city, back and forth, these yellow taxi cabs, and they're very expensive to get. The medallion, I think, is like $500,000 to own a taxi cab in New York City. So there was a case where a gentleman bought a medallion. He set up a entity, and as my colleague was just describing, he had the expectation that if that car hit somebody and there were damages, that his personal assets would be protected. However, the court looked at it and said, you're using the same bank account for this taxi cab business as your personal assets. You're not following any of the quarterly reporting. You don't have a separate board of directors. When we look at this in totality, we're going to pierce the corporate veil. What that means is, if you had otherwise done everything appropriately, we would protect your personal assets. The corporation will be a separate entity and you would be protected. However, because you did not follow all these rules, we're going to look past the corporation, and that's what they're calling a corporate veil, and we're going to attack you personally. So what I say all that to say, when we're talking about C corporations, we're talking about the most onerous rules and regulations when it comes to maintaining an entity. Your typical public company is going to be a C corporation. It's going to have a board of directors. It's going to have shareholders. There's going to be significant reporting requirements. And the point here is, those big corporations have a lot of money. They have a lot of revenue, and they have a lot of means to make sure that they comply with all those rules and regulations. Your average, person running a lemonade stand, or even a small franchise, may not have the appetite, the wherewithal, or the finances to keep on top of all of the rules and regulations that are required for a C corporation. So the good thing about a C corporation is it's the tried and true, the oldest kind of entity, and it's your run-of-the-mill public company If you're ever going to seek financing, it's a good entity to think about, venture capital and so forth. Or if you're on the cusp of going public, congratulations, you're very successful. But for your average person, it may not be the best fit. Next slide, please. And this is what we're talking about here. Administrative duties are burdensome, the most burdensome. And corporations must comply with securities laws. Securities laws are a very big topic. And what's important to remember there is be very careful if you start selling equity in your company, no matter what it is, whether it's an LLC, whether it's an S Corp, anything that you decide to start, if you are going to start selling equity in that company, meaning you're selling part of your business for X amount, and that entitles the person who holds that right, a percentage of your business, you need to be very careful because there are a lot of securities laws that could come into play. Next slide, please. Tax considerations. The one thing I want you to think about here is just double taxation. We've talked about this earlier, but I just want to kind of dumb this down a little bit so everyone understands. I think, this is just me speaking personally. I think whenever you think about the entity you want to create, the number one factor likely will be taxation. Among other things, we're talking about a lot, but taxes are very important. What's important to remember about corporations is that there are two levels of taxation. So you have a lemonade stand that does very well. It makes $1 million in a summer. That lemonade stand is responsible to pay taxes for itself. Now, let's say, the lemonade stand, you spent $500,000 in order to run the lemonade stand. So you made $500,000 in profit and you want to pay yourself. You want to actually use that money. It's time to buy a house. It's time to buy the Ferrari. Okay. That money has to be transferred to you, but then you need to pay taxes again, just like you pay taxes, if you work for someone and they pay you a salary. So the important thing to remember is that Uncle Sam takes a piece twice, once from the corporation when it makes its money, and again, when it pays its shareholders. Next slide. Okay, so S corporations, these are very interesting. This is a benefit, and I want to highlight that we have pass-through taxation here, as opposed to the C Corp, where Uncle Sam is taking a cut twice. The S Corp allows you to pass the revenue and expenses onto yourself personally. And in essence, you would only pay the money at your personal level as an attachment to your tax return. This could be very good, especially if your business loses money, because you can deduct the expenses that the business has. Let's say your lemonade stand didn't make money in the summer, and it took a loss. Now you can claim that loss on your personal returns. Let's go to the next slide. I want to highlight a couple of other things. Please keep in mind, only 100 shareholders. That's a unique feature. That's S Corp is the only entity that has a limit on the number of shareholders. That's why whenever I think of S Corp, I like to think of small, because it must be a small corporation. Another thing to remember is that you can't read it here, but there's a limit on who can be shareholders. So it says here, you can't have a corporation, you cannot have an LLC, you cannot have a partnership. And what you can't see, if your windows are on the right, like mine, is that you also can't have a foreign citizen. So if you have immigrant family members, if you have people that are not citizens of the United States, remember, they can't own any of your S Corp. Other than that, I think the S Corp is a reduced version of the C Corp, and it allows pass-through taxation. That's the main points to understand. Administrative duties are more burdensome than your LLC, but less burdensome than your C Corp. All right, let's go to the next one. And we've talked about this, the pass-through taxation piece. The one point I'll say is, as opposed to the LLC and the partnership, the pass-through taxation can be different. You should check with a tax professional, a CPA, because the different entities may allow for different reporting standards. Okay, next one. All right, limited liability company. For me, I think this is the most common entity. It's the easiest to form. It's very similar to a partnership, except it's limited liability. You are protected as long as you meet a very limited amount of corporate record keeping. You can be protected and your personal assets can be protected. This also allows for pass-through taxation. In this case, limited LLCs typically are just reported on your 1040 if that's what you file. I'll also say oftentimes real estate assets are held in LLCs. So anyone who's thinking about a real estate business, you find a lot of real estate assets to be held in LLCs. And it doesn't have the shareholder restrictions that an S Corp has. So you can have your foreign citizens, you can have other legal entities holding the LLC equity. One thing to note, for what it's worth, here LLCs are typically held in units, but they are, you can sell them just like shares of a company, and you can split up the ownership. But for an LLC, you're typically going to have an operating agreement and articles filed with the state, and there's not much more than that. It's a very easy entity to set up and to manage. Okay, next one. This is more about what we talked about. If you don't end up maintaining the documents correctly, and I think sometimes people can be lulled into a sense of comfort with the LLC because there really isn't a lot of ongoing reporting requirements, but it is still important that you maintain your books and maintain your corporate responsibilities. Next. And we talked about the pass-through taxation as well. California franchise tax, just to mention it, this is just, I believe it's $800 now that you have to pay each year that your business is operational in California. A lot of states require this. And so with your LLC, you're typically going to pay, in whatever state you do business, in whatever state it's organized, an annual fee. All right. Chris from Jenner Black is going to take over for the next set of slides.
Yeah, thanks, Christian. I'm just going to take the last few minutes here to talk about kind of some of the formalities about the various entities that we've talked about. So basically the steps that you need to or don't need to go into in order to create the businesses that we've been talking about. So typically, the creation of these entities is going to incorporate some, but not all, of the steps listed here. The selection of a form, the legal form that we're talking about, what you want to call the business, the various documents you have to file, whether you need an employee ID number, whether you need to register a fictitious business name, get various tax or seller's permits. Like, some of these are going to come into play depending on the kind of entity that you select. So Choosing legal form, that's exactly what we've been talking about, as Kai and Christian kind of went into detail on. There are pros and cons of each. Some are easier to set up than others. Choosing a name, it's going to depend on the kind of entity that that you select. Some have some specific requirements about what the name of your entity can be. But the primary rule, if you're registering an entity, is that the name, unless you're selecting a different kind of form from an existing entity, the name is going to have to be unique. So you're going to have to pick your own unique name, and the IP people might talk about the trademark problems you get into if you don't. So this is the basic naming requirements. For sole proprietorships, to Kai's point, you can kind of fall into it. So the name of the entity is just going to be your given name, probably. For general partnerships, there aren't specific requirements to identify the partnership. For limited partnerships, you actually do need to identify the entity in the name. So it has to include limited partnership or LP. Corporations, it's similar. You need to identify that it's a corporation, it's incorporated, or use one of the abbreviations listed here. Same with an LLC, the name needs to include limited liability company or LLC in the name. Organizational documents, again, sole proprietorships, you really can create by default. So there is no specific requirement to file an organizational document to create a sole proprietorship. General partnerships, the partners need to file what's called a statement of partnership authority with the Secretary of State, and should prepare a partnership agreement to, like Kai mentioned, to kind of describe the obligations of the different partners and the kind of control, like how the different partners are going to interact in controlling the business. But there are default rules that will apply if the partners don't do that. Limited partnership is similar. You would file a certificate of limited partnership with Secretary of State, and then prepare an agreement or not. But if you do not, there are default rules that are going to apply. C and S corporations do need to, like Christian was saying, file articles and observe the corporate formalities that he was talking about. That's one of the reasons why they are more complicated both to create and administer than some of the other types of entities we talked about. An LLC, again, it's pretty straightforward. You file articles of incorporation and sign an operating agreement governing how the members are going to interact in running the business. A federal employee ID number is probably going to be required because that is going to be the number that the IRS is going to use to identify your business and to track the tax forms that your business is going to file. And you can get those, directly online from the IRS. To register the business names, again, there are different requirements depending on the different businesses. Depending on what name you're operating under, you might need to file what's called a fictitious business name statement with the local county recorder, but that's going to depend, again, on the name that's selected and the name that the entity does business as. And I'm just going to talk a little bit right here at the end about licensing. Most cities will require businesses to register with the city tax collector, regardless of what the actual kind of business is. That's typically called a business license. If you are going to sell goods to the public, you need to get what's called a seller's permit, and that's going to govern basically the sales tax arrangement that you're going to need to enter, that you're going to need to operate with the California BOE. And lastly, there might be other permitting requirements depending on the type of business that you're in. And there is a website, the CalGold website can give you some information about what kinds of licenses might be required depending on the kind of business that you're operating, and provide contact information there. We're just a shade over time. I don't see any questions in the chat, but that's pretty much all that we had to talk about. Happy to answer any additional questions. Otherwise, I can turn it back to Bria.
Thank you so much, Chris, and thank you, Kai and Christian as well, on an amazing presentation. Are there any questions for them? Anything related to the different types of entities or anything? Okay. If there are no questions, just double checking here. Nope, I'm still not seeing any. If there are no questions, then you guys did great. That means that you explained everything very well. So next, we're going to have a presentation on the contract basics, and the attorneys who are going to be talking for that are Mike McNamara and Catherine Herman and Nora Tillmans. Thank you guys so much for presenting on this topic, and I'll turn it over to you.
Thank you, Bria. Hello, everyone. I'm Mike McNamara, and it's an honor to be here talking to you. And in fact, it's something very close to my heart because I was a small business owner for over 20 years. It was a law firm business, but a very small 8-lawyer business that I ran for 20 years. I formed it, and I was overwhelmed initially with all the different decisions you have to make, all the issues you have to grapple with. How do you run a business? How do you hire employees? What form do you have? How do you keep out of trouble? You know, what do you need a license? Do you need that? And so, you know, this is, and I'm a lawyer, and you know, it can be difficult. So I really do relate, and I'm glad to be here. The topic I have today is I'm going to be talking about some contract basics. And if we could go to the page 4, please, of the slides with the topics to cover. Nora, thank you. And we're going to cover these topics. And I'm going to talk about the first bullet point, which is overview of contract formation and enforceability. And then Nora is going to talk about the terms of a contract and what happens when one party breaks a contract. And Catherine's going to jump in and give you tips and practical pointers for contracts. So why don't we go to the next page, please? Okay, what is a contract? What a question that is, because if you think about it, it's one of the most important things to understand when you're a small business owner. If you don't understand basic contracts, you're in jeopardy, because it's what makes a business either succeed or fail, how you can deal with your basic contracts. And so, you know, it starts with an understanding. What is it? What is a contract? Is it just a promise? Well, promises can be contracts, but not all promises are contracts. A contract is a promise that's enforceable. And so that begs the question, how do you have an enforceable contract? And, you know, and I think we should unpack that a little bit and talk about the different types of contracts, and then sort of work into how do you form an enforceable contract. Well, there's basically 2 types of contracts. There is express contracts and there's implied contracts. But they share a lot in common, but they're very different. What do I mean by an express contract? Well, an express contract can be written or oral. A written contract is exactly what it sounds like. It's in writing, and you can read it. And that's probably the safest form of contract that you could ever have, because if there's a dispute or some question down the road about the terms of a contract, if it's in writing, it's pretty easy to prove it. The other type of express contract is an oral contract, and many types of oral contracts are enforceable. The problem with oral contracts, if there is a dispute down the road, or a question or of interpretation or something, sometimes it's difficult to prove an oral contract. So again, having a written contract sometimes is the safest course for a small business owner, but not always. And the other type of contract, an implied contract, is something based upon the circumstances, where maybe you didn't discuss it exactly, but there are circumstances and actions and things that are relied upon, And it probably gets beyond the parameters of what I'm talking about today, but I just wanted to let you know that there's a lot of different types of contract to deal with. But let's talk about enforceable. Okay, I started off and it's a little confusing. I said express contracts can be written or oral, but guess what? Some contracts have to be in writing to be enforceable. And that's what you see in this second bullet point here. You know, I don't know if you've ever heard the phrase statute of frauds, but for example, if you have a contract involving real estate or the sales of goods over $500, or contracts require more than a year to perform, and it can get complicated. But you might have a perfectly valid oral contract, and then later you go to enforce it and you find out it's not enforceable because it was the type of contract that had to be in writing. Let's go over to the next slide, please. And again, the one takeaway point from the other thing is that, let's say you have the type of contract that doesn't have to be in writing. Is it a good idea to still put it in writing? Probably. Yeah, I'm just telling you, because that way, you know, the number one rule that as a small business owner is that you want to be really clear in your dealings with customers and partners and employees and everyone, so that there's never any question as to what your intention is and what you're required to do or not do. And, you know, a contract is one way to do that. Now, in enforceability, as I said before, let's say you have a contract and it's not enforceable and you were relying upon it. Well, that's a real problem. So you really think about what is an enforceable contract. And this slide sort of says the very first premise is a contract is enforceable if there's some remedy for its breach. Well, that makes a lot of sense. If there's no remedy for the breach, how are you going to enforce it? You know, you have to have some way to enforce it. And the next bullet point talks about how valid contracts are enforceable versus unenforceable. And they talk about the difference between void and voidable contracts. And for example, the example they give for voidable contracts is that, let's say you enter into what otherwise would be a very enforceable contract with someone under 18 years old. Well, you know, a child can reject a contract, and you need to be careful about that. Then there are certain types of contracts which may or may not be enforceable because of public policy or statutes. Like one of the examples here would be non-competition agreements. They say, generally speaking, non-competition agreements are not enforceable. Well, yeah, that's true. There's a statute. In fact, not to bore you with statute numbers, it's 16600 of the Business and Professions Code, but there are exceptions. Like if you're a small business owner and you sell your business and all the goodwill associated with the business to someone else, and you agree not to compete with your business as part of the sales terms, that type of non-competition agreement is potentially enforceable. So, you know, there's a lot of nuances and things that we're not going to be able to cover today. We're just trying to give you sensitivity to the different types of considerations. Let's go to the next slide. You know, the next slide covers formation of a contract. And in law school, what you get drilled into your head from day one is that in order to have a contract, you need an offer, acceptance, and consideration. And you know, that makes sense. You know, you can't just unilaterally declare your intention and expect that to be binding on some other party. You know, you need to state the offer, and then the other side needs to agree to it. But that isn't really enough unless there's consideration. And by consideration, you know, the typical example is, for example, money paid. Let's say I will do X, and they say, okay, we agree to do that, you know, and then the consideration would be the exchange of money. And, you know, so you always need to think about it, but there needs to be those elements, and there's a ton of case law on each of those elements and how it works. The other thing you need to consider, for example, there's a lot of other reasons why a contract may or may not be enforceable. For example, let's say you have what would otherwise be a very enforceable contract, but it's for an illegal purpose. Well, there's a public policy against that. You know, illegal contracts, you can't enforce those, things like that. Or talking about consideration, this talks about a gift. A gift is a little different than consideration. If one party says, I'm going to give you X and you accept X, but you don't agree to give anything in return, it'd probably be hard to enforce that gift. And so again, this is a subject where there's more complexity to it than meets the eye. But let's go to the next slide. Let me sort of end my section by telling you the real basic thing, which is what you want to take away from this is, in order to have a contract, you need to have a meeting of the minds. That's how they always put it in law school and in all the cases. And that's a really great way to think of it, because you need something that's clear, that's not vague. You need an offer, an acceptance, consideration, but you need both parties to understand what that is. In order to do that, and Nora's going to talk about terms, you're going to need terms that are sufficiently definite and capable of being understood and applied and things like that. So with that, I think I probably overstayed my welcome, but it has been a pleasure. And I'm looking forward to meeting those I'm going to be consulting with during the consultations. And I'm going to turn this over to Nora.
Thanks, Mike. Hi, everybody. My name is Nora Tillman Shear. It's so nice to be here. Thanks so much for having me. As Mike explained, I'm going to be discussing terms of a contract. So we know now that you need an offer, you need acceptance, and you need some amount of consideration. But in order for there to actually be a formal contract, and in this case, now we're sort of talking more about these written contracts that are more easily enforced and more likely the types of things that you'll be dealing with in your companies. So first thing, you need to know who the parties are. The full legal names of the parties need to be included in the contract, and the party doesn't need to be individuals. It can be a person, it could be a company, it could be another legal entity, and it can be among multiple people. It doesn't just need to be between two. Again, what Mike was explaining as to the meeting of the minds, what the four corners of the document of the contracts needs to show is that two people or more came together and made an agreement. And at the time of making the agreement, they agreed about all of the terms and the definitions of the agreement. So to the extent there might be something that could be interpreted multiple ways, it's important that the actual contract explains what those terms are. So I'm sure you've seen it at the beginning of contracts. There's a bunch of things in quotes, and they're just a bunch of defined terms. And that's to show that at the time of the writing of the contract, the parties to the contract all agreed that this was in fact the definition of the term. So it avoids ambiguity and vagueness, and it keeps everybody on the same page. It also shows were there to be some sort of issue in a breach in the long run, it could show the judge that there was in fact a meeting of the minds. There's going to be sometimes some introductory material. These are called, recitals, or usually they begin with the word whereas. Whereas on this date, Nora met Paul and decided they wanted to go into business together. Whereas Nora sells apples. Those are the kinds of recitals that would sort of start a contract, again, to show that there was a meeting of the minds. These two people came together, and they, at that time that the contract was formed, they had the same idea about what the contract was agreeing to. And then what are the intentions or the reasons for entering into the agreement? These aren't always included, but again, this is another small thing that can show a court in the long run that there was a meeting of the minds. You're probably going to have representations and warranties. These are the promises of the contract. So, as Mike described, there are so many different types of contracts, We're not going to get into all of them today, and all of your different types of businesses probably will have different types of contracts that they need. Some will be, a contract for a sale of goods. Some will be leases. Some will be employment agreements. I'm an employment lawyer, so my expertise is in employment agreements. There might be an NDA. So the types of representations and warranties that are going to be in the contract are going to be very specific to the type of contract that you are dealing with and the type of agreement that you're entering into. And then you're going to be having the deal terms. So these are going to be the bargained for details of the agreement, the responsibilities of each party in the agreement, any details about the money that's going to be paid, how it's going to be paid, if it's for a sale of goods, if there's any quality terms that need to be included, and any sort of delivery schedule. These are going to be the things that you're going to want to include in the deal terms as specifically as possible, so that there is a meeting of the minds and so that everybody's on the same page and there isn't confusion, in the long run. So as Mike explained, a contract is a very flexible document, and there are many different types and they can be used in many different ways. What I'm going to go through now pretty quickly are these sort of general term boilerplate issues that are going to come up in almost every contract. For instance, the first one here, attorney's fees and costs. So if there is a breach and there is a lawsuit, who is going to pay the fees and costs? Well, usually it's going to be the losing party. And that's something that many parties want to have included in the contract from the very beginning. If we ever have an issue, the loser is going to pay for the attorneys. That's what attorneys' fees and costs. ADR, or alternative dispute resolution. That means, we've been hearing a lot in the news about arbitration and, arbitration contracts, arbitration provisions, whether they're viable under state law, under federal law. As of now, there are some state laws that are making sort of forced arbitration provisions void, but some contracts are still going to have, if there's ever a dispute under the terms of this contract, we're automatically going to mediation, and this would limit the costs. So that way, if there were some sort of issue in the long run, you wouldn't necessarily be going to court where the fees can be really high, but rather you would automatically going to mediation or arbitration. And there's pros and cons to all of these things. And these are not all necessary to a contract, but these are things that you're going to pick and choose from in your situation. A choice of law provision, what state's law will apply. Usually that's going to be the place where you're doing business or where the transaction is taking place. For instance, in my situation, again, I'm an employment lawyer. So if I have an employee in California for a California company, most likely my choice of law provision is going to be California. Jurisdiction is where a lawsuit must be filed if there is a dispute. And again, usually that's going to be the place where the business is being done, but it doesn't always have to be. Waiver is a special contract issue that basically means just because I don't enforce it now doesn't mean I won't ever enforce it. So basically means that even if the contract doesn't go exactly according to plan, that doesn't mean I'm waiving my obligations. Severability is another sort of intricacy of contracts, that if one of the provisions of the contract is invalid or unenforceable, one of the things that Mike was explaining that would make a contract unenforceable, that one provision can just be severed from the contract, leaving the valid contract intact and just taking out that one piece. If you don't include a severability contract, a court can very easily rule that your contract is void or unenforceable because you didn't have that severability provision. Integration says that basically everything that is here is everything that the parties intended to include. And so, later on, if there's an issue, one of the parties can't say, oh, well, we discussed X, Y, and Z, and it was a mistake that it never made it in. Well, no, we have an integration clause. Everything that you see here is what we decided on. Notice, if any any sort of notice needs to be given under the contract. That would be a notice provision, and any sort of relationships. For instance, again, in employment contracts, we often will have, some sort of agreement with an independent contractor. And as you might know, independent contractors sometimes are misclassified employees, but sometimes they're true independent contractors. And so in our contracts with them, we say, this is not an employment agreement. This is an agreement with an independent contractor, that sort of thing. Oh, okay. Some more, I'll try to get through them a little bit more quickly. Assignability. So can you assign the contract to somebody else? That might be something that a contract could be assignable. For instance, something like a sale of goods. If you don't want to be the buyer in the end, perhaps you might want to assign the contract to someone else if they wanted to buy those goods. But for instance, in an employment agreement, if you have an employee and that employee has an employment agreement with you and they assign it to somebody else, you might not want that other person to be your employee. So you would have a no assignability clause in your agreement. There might be a limit on damages. There might be a specific amount that the contract states is the maximum amount that is recoverable under the contract if there's a breach. That's another way to sort of limit liability. Indemnification, one or both parties guarantees that it's going to cover the liability and the costs of disputes brought by third parties. Counterparts, the parties can execute copies without needing everyone to be present at the same time. That's one of the sort of old school contract things that everybody needs to be there. And then another one that's probably come up with some of you, at least during the pandemic, I know it has for me, force majeure, which is it's this clause that establishes that the agreement will be suspended in the event of an unseen circumstance. So I was supposed to get married in April 2020. Come March 2020, I was furiously reading through all of my contracts, finding out if I had a force majeure clause. So something to think about. So then what happens when a contract is broken? A lot of the things that we discussed in the first section are to prevent issues when a contract is broken. So disputes do and often arise over contracts when one or both parties might accuse the other of breaking some part of their obligation under the agreement. And a party's failure to fulfill their end of the bargain under the contract is known as breaching the contract. When a breach of contract happens, one or both of the parties may wish to have the contract enforced on its terms. So that would be, you didn't perform, you actually must perform now because that's what you promised to do under the contract. Or perhaps the time for performance has passed or anything like that. And then you might want to recover for your financial harm. So by far the most common type of damages for a breach of contract is monetary damages. That the first of which is compensatory damages. So that is damages that compensates you for the breach to be put in the position you would have been in had the other party done what they were supposed to do. But there are other types of damages that you can seek under a breach of contract. There's specific performance, which is what I just explained. It's where you get a court order that the other party has to actually fulfill the promises of the contract. They have to perform, but it's generally not available as a remedy, but sometimes can be used to enforce the transfer of real property or very unique goods. Monetary damages are much more common in a breach of contract. Rescission, which is sort of bringing the parties to where they were before the contract was ever made. So returning the parties to the position they were in before the contract was entered into. And then there's other additional types of monetary damages in addition to compensatory damages. Consequential damages, which is basically paying for the problems that were caused by the party breaching. Punitive damages, but only if there was a willful or a reckless breach. That's very rare. Or liquidated damages, and that's sort of what I was talking about before. An actual term of the contract can say the maximum for breach of this contract is X amount. So that would be the liquidated damages. Those are a very quick briefing on types of terms. I'm going to turn it over to my colleague, Catherine Herman, now, who's going to be giving you some tips.
Hi, everybody. My name is Catherine, I'm also at Fox, and I will try to keep this pretty short. Honestly, Nora and Mike covered a lot of this in their wonderful presentations. So these are just some practical tips when you are entering into contracts with other businesses, with service providers, things to keep in mind. So Mike alluded to some of this in the beginning. You can have an oral contract. That's a valid contract, except for in some of those exceptions. But generally, it's a better idea to keep everything in writing. And if you think about it, that makes sense, right? Because if you have a meeting of the minds, like Nora talked about, and you write everything down, if there's a dispute, inherently within a dispute, the two people are going to have different ideas of what the contract was. If the contract is oral, it's going to be very hard to prove in a court or in mediation or whatever you're doing that one side's interpretation was right and the other side was wrong. If you have a written contract, the court can look at what are called the four corners of the contract and determine, okay, this is what they agreed to. This is the meeting of the minds. It's much easier to enforce a written agreement. And so if there's any ambiguity in the contract, if the phrase doesn't really make sense, if it could be construed one way or the other, the ambiguity is construed against the drafter. So if you are a business and you want to control the contract, you want to draft the contract, just remember, if something doesn't make sense, if something's ambiguous, it's going to go against you. So try to be as clear and concise as possible, which brings us to our second point, keep it simple. Lawyers, sometimes love to use what we call legalese, but generally it's a very good idea to use short, clear, declarative sentences that make clear what both parties intend. Number the paragraphs with clear headings, 1, 2, 3, and then if there are subpoints, 1A, 1B, 1C, so that when you're discussing the contract, when you're negotiating the contract, and when you're enforcing the contract, you can easily point to the provision that you want to talk about. Okay, next slide, please. So this is important, and this should be something that is a representation or warranty, a promise in the contract. Make sure that the person that you're negotiating with actually has the authority to bind the business that they're representing and to make sure that the business performs its obligations under the contract. Usually something like a representation in the contract is sufficient. If not, if you're concerned, you can always ask to see things like corporate resolutions that give the person you're talking to the authority to bind the business. Be sure to use the correct legal entity names, like they talked about in the first presentation. It's important to get the entity names right. You don't want to end up in court with an entity that you weren't negotiating with and that wasn't a signatory to the contract. And then, sort of as we've been saying, include all the details that are important to the obligations under the contract. If you guys talked about things in an email, exchange, if you talked about things on the phone, make sure all of that gets into the contract, because with a few exceptions, the judges are only going to look at those four corners of the contract. If you guys had a conversation off to the side and you agreed to something different, the judge isn't going to take that into consideration. He's only going to look at what does the contract say. So don't leave out details that were discussed verbally. If you forget something, you can always amend the contract later. Okay, next slide, please. Okay, this one is super important. Be specific about payment obligations. So make it clear who's paying whom, obviously. When should payments be made? Are you going to issue an invoice? Will payments be made upon receipt of invoice? Will payments be made within 30 days of receipt of invoice? Are there going to be monthly payments, quarterly payments? Put all of that in the contract. What are the conditions for making payments? Will you take a check? Will you accept a wire transfer? How do you want that to be done? Are you going to have like a milestone-based payment system, or are you going to do something more like a time and materials? That totally depends kind of on the industry and the relationship of the parties. But sometimes there's an upfront payment, and then there's a payment based on completion of specific milestones. And then other times the service provider will bill you for their time and their labor and their materials, and that bill will come at the end of the month and then you pay it. Does the payment depend on one party's satisfaction? Usually if you're the business engaging a service provider, you're going to want to be satisfied with the work that they've done before you pay them. The service provider, on the other hand, is going to say, well, wait a minute, you can just say you're not satisfied and refuse payment, even if we perform perfectly good work. So that's usually a point of negotiation. And I've already sort of covered this, but are the payments going to be made in installments, or are you going to pay all at once at the end of the contract when the work is done or when the goods are delivered? Depends on the kind of contract we're talking about. Okay, next slide, please. Termination, also very important. There are specific ways in which the contract can be terminated. Maybe the parties only want to terminate the contract if one side breaches the contract. But think about something, a circumstance where you're a business, you want a counterparty to perform services, but before they get started, they go up in smoke, they go bankrupt, right? You should be able to terminate the contract at that point and not be on the hook to their creditors for money that you're paying for something that was never done. So that's an important element to include in termination. Do you want to be able to terminate for convenience? You get a month into this thing and you decide you don't want the services they're providing anymore. You want to be able to terminate in that case. Usually, again, the service provider is not going to necessarily like that, but these are all points of negotiation. In resolving disputes, so, Nora talked about this at some length, but typically if a contract is breached, if there's a dispute around the contract, it goes to court. And important to note that if a contract is worth less than $10,000, it can be handled in small claims court, which is, a much easier forum than an actual full court of law. Not that it's not a court of law, but you can also use alternative dispute resolution. You can mandate in the contract that before you go to court, or instead of going to court, you're going to mediate, or maybe you're going to arbitrate. That can be cheaper, but there are some pitfalls with that too. It depends on the kind of contract that you're entering into. So there you go. Next slide, please. Governing law, Nora went into this, but typically contracts are governed and enforced by the law of the state where the agreement is made. Sometimes you decide you want to use another state's law, and two parties can agree to that. Two parties in California can agree to use New York law, they can agree to use Delaware law, and there might be legal reasons for them to want to do that. But typically your basic contract is going to be the law of the state where the contract is made and the obligations are performed. And finally, something very important to consider is confidentiality. If you have trade secrets, if you have proprietary elements of your business that you want to keep secret, that you don't want this service provider or this other business to use for their own benefit or tell anybody else, it's important to either have an NDA, which Mike talked about earlier, a separate confidentiality agreement, or to include confidentiality provisions in your contract that basically say that certain things that you tell the other side or the other side tells you, or documents that you exchange, are confidential, and that if they disclose those, then they're in breach of contract. So that can be very, very important depending on what you're looking to do.
And thank you guys so much for doing amazing presentation, Mike, Catherine, and Nora. And so now we're going to move on to our final presentation. It's going to be on intellectual property. We have Julie Shepard, David Singer, and Amanda Hamilton, who are going to talk about the different aspects of IP law. So thank you guys so much, and I'll turn it over to you guys.
Great.
Hi, everyone. I'm Amanda Hamilton with Fox, and Julie and David from Jenner will be speaking to you as well. So we're talking about intellectual property issues for you guys. Can go to the next slide, David. So there are four main types of intellectual property. First being trademark, second is copyright. We have patents, which we are not covering today. They that handles inventions basically, and it can be very, very technical and complicated. So if that's something you think you need assistance with, we can identify that in the consultations, but it's not part of this presentation. And then trade secrets will be the last category that we'll talk to you about. Okay, so intellectual property is important for two main reasons, and you should be thinking about it from both of these perspectives. So the first is wanting to be mindful of protecting your own intellectual property, which is basically any sort of, intangible asset. So the company name, your logo, those types of things. You want to protect those, and they're your property, and they're very valuable to you. That's very integral to your business. So you want to protect those and make sure that other people aren't also using them. At the same time, you want to keep in mind that you don't want to infringe on other people's intellectual property, right? So that kind of goes to the earlier point the entity group brought up about choosing a company name that isn't already chosen by someone else, because then you can be hit with a intellectual property infringement lawsuit, which we don't want. So those are the two things to keep in mind with IP. And then trademarks are the first area we're going to discuss. So trademark law, their states will have a similar law as well, but the main law is called the Lanham Act, which is the federal law related to trademarks, and that protects words, names, symbols, or devices used in commerce, so in business, and they indicate the source of that good or service and an affiliation. So the purpose of this law is to protect the public's ability to distinguish among goods or services and prevent consumer confusion. So you want to know that when you're buying something that it's from the real, whatever company it may be, and that you can trust that. And that's the purpose of the law. When you have a trademark, it's potentially for unlimited amount of time, as long as it's not abandoned, which means as long as you're continuing to use it. And then territory. So we specifically are talking about the US here. Trademark is going to be country specific. So what we're discussing here is for the United States. Okay, so there are different types of trademarks, and you guys are going to see on this slide a lot of company marks that you are probably familiar with. So most.
By the way, I didn't know that was in there, Amanda, that sound.
Oh yeah. So we have, it can be words, just like a business name, but can also be a word with a image or some sort of special style to it. So you'll see McDonald's, Google, and then here we have the Nike phrase, just do it. So it could be the company name and then stylized, could be a special phrase, that sort of thing. It could be a symbol on its own. So here we have the Nike check and the Microsoft symbol. So when you see those, you know what it's associated with without needing the name written out. Colors can be trademarked. There's, infinite colors out there. So if something has a very distinctive color, it could be trademarked. We have the jewelry company Tiffany, their blue color here, and then the brown for UPS, which I didn't actually know was trademarked by them, but that's pretty interesting. And then sounds as well could be trademarked. So we have the Intel, the little noise that comes on the computer, and then the NBC, the NBC like dinging sound that comes on as well when you're watching on that channel. All right, there are different types of trademark protection as well. So a trademark is technically for a source of goods, and you'll see a little TM to indicate that. Service marks, a lot of times trademark is used interchangeably to refer to service marks as well, but technically service marks are for a source of services. So if you're selling a service rather than an item, it would be a service mark. Collective marks is probably won't be relevant for you guys, but that's to indicate membership in a group. We have NFL and Girl Scouts as examples here. Certification marks indicate some sort of special certification. This comes up a lot with food, especially like organic items or certain things that you know, you want to be able to trust some sort of certification that the item has. And then domain names, which is a website name, those can be trademarked as well. But you know, you could have a separate trademark for your website and then for the company name itself. So those are two different categories there. So choosing choosing a mark. It's important here. This goes back to the earlier presentation when you're starting out your business, and some of you that, you know, people can pivot and rebrand and go with a different name if they realize they didn't choose a strong one. But the strongest types of trademarks are the ones that are inherently distinctive on their own. So the term for the best category is fanciful, which is basically a made up word that you created just to represent your business. So Google and Xerox are two examples, which are now so, you know, so normal to us, but those were made up words originally. Arbitrary marks are real words, but used in a way that's not at all related to what the real word means. So camel for cigarettes obviously has no actual connection to the animal. And then Apple, the tech company, versus the item. Suggestive, these have some connection between what you're saying and the basic meaning, but it's a little bit of a have to stretch your brain. So like Hot Pockets for the food, and then Chicken of the Sea for the tuna. Going down, so as we're going down, we're getting less strong with these marks, but descriptive are ones that describe an aspect or characteristic of a product. So we have Kentucky Fried Chicken and Raisin Bran here. In terms of small businesses, it could also be like Joe's Car Repair or something like that, that, you know, you're just describing what the business is. And then generic words are not distinctive at all. Just basically say the product or service. So it would just be like lemonade stand. And then something else to mention here that's a little bit interesting is words like Google and Xerox can kind of become generic over time. So you may say, oh, will you Xerox that for me? And you just mean make a copy of it. You don't necessarily mean use an actual Xerox brand, or, you know, the same thing with Kleenex becoming the term for tissues. So that's just kind of an interesting thing. We'll go, I see a couple questions which we can go to at the end, I think. We'll keep going here. You can go to the next slide, David, thanks. Okay, so the last thing here to talk about is when you're choosing a mark, what do you do? Where do you start? How do you, go about that process? The first thing to do that can be really helpful is going to the USPTO website. So that's the United States Patent and Trademark Office government site, and that's where trademarks are registered. So they have a special section of their website with the search system called Test. And you can go on there and try to search. So if you have an idea of something you want to use, you can go on there, type in the name and see what comes up. One thing I want to mention there is something coming up on that site doesn't automatically make it not available to you. This is where it's really helpful to have a lawyer's input because, some marks may be abandoned, which means, they're not being used anymore. So then they're available for others to use, or they're being used and they're trademarked in a very limited category of goods. So you'll have to, when you register, there's categories that you choose. So if someone is using something in one category and you are doing some totally different type of business and in a different, area, that type of thing, you may still be able to use it, but it's helpful to have an expert on that. You can also search domain name registries if you have a specific website name in mind. I would also suggest here, what I've done in the past that can be really helpful is just Googling the business name that you have in mind and see what kind of Google results come up, and then also checking social media, because that's another place where someone may be using something pretty consistently in the market, but if they haven't actually registered it with the USPTO, you may not see it there, but they still do have some protections, although they're not registered. And with that, I'll let Julie take over with copyright.
Thanks, Amanda. David, if you could advance to the next slide. Thank you. So hello, everybody. Good evening. My name's Julie. I have the pleasure of talking with you about copyright and giving you the express course of that with a bit of a focus on small business issues. David, if you could remove the build and just add the last 2 points on that last one, that would be great. So the purpose of copyright law is to encourage the creation of creative works. And how that is implemented is that there's a statute, the copyright statute, that protects original works of authorship fixed in a tangible medium. Breaking that down just a little bit for you, what does it mean to be an original work? It has to be independently created by the author. And the author is an important concept in copyright law because it goes to the issue of who will own the copyright. And generally speaking, it's always the author of the copyright unless they've transferred ownership. And then creativity, there has to be a modicum of creativity required. You can't protect facts, but you can make potentially protect the arrangement of facts. So it doesn't have to be the great novel to be copyrighted, but there does have to be display of creativity. And then in the fixation requirement is in a medium for which the work can be perceived or communicated. And really all that means is that you do this in daily life. It's something that you can watch with your eyes. You can read a book. You can hear a song. It's something that is recorded in some form and can be played back or transferred to another person. So an example of what would not be copyrighted is an unrecorded speech that has never been written down, or something kind of like a jazz performance. So going to the next slide, please. And then, so can I have the, yeah, thank you. Copyright protection. I don't want any builds because I just want to be able to, and for the interest of time, I know we have limited time, even though there can be a nice way of presenting when you have a little bit more timely leisure. But so copyright protection arises at the moment of fixation, what I was just talking about, when the work is in the tangible medium, the author at that time has the copyright in the work. So you don't, and again, it goes back to the author. The author of that work will hold the copyright. And you don't need to register that work with the Copyright Office in order to hold the copyright. However, registration of the work with the Copyright Office is necessary if you ever want to enforce your legal rights to bring a suit for infringement. And also, it affords additional benefits if you register the work. For example, if the work is registered at the time that someone infringes it, you have the ability to request statutory damages, which are in a range depending on the egregiousness of the infringement. They can range from $250 all the way up to $150,000. And you can also get attorney's fees. And then this next issue, we're talking about the importance of authorship. There's an important exception to that, and it's important. This is an important point for, I think, for small businesses to focus on, both if you're on the creative side and if you're on the side that is hiring someone to do creative work for you. The exception to authorship is that the copyright will be held by the employer of the author if the work is prepared by the employee within the scope of his or her employment. So if you hire someone and they're your employee, to prepare a manual for your business, that written work product would be owned by the owner of the business. However, if you have specified that that person, as Nora was talking about, is an independent contractor versus employee, you may not own that copyright. And so this is where the issues of our contract team came in. That's an important issue of bringing home, having a contract potentially with the employees or independent contractors who specify clearly who is going to hold the copyright. And if there's a potential that the owner of the business is not the author, that if they want to own the copyright, that their contract provides for that. And on the flip side, if you are the person providing the creative work, you're the independent contractor or the business that's providing creative work, i.e. creating a website for someone, painting their food truck in a very creative design, and you want to hold the copyright, then your contract needs to specify that and protect you. So those are considerations to be made for you. And things to think about as you are going forward if your business requires that. And then on the joint work, I would just point out that 2 or more authors, when they contribute to one work, right, there are 2 people working on the manual, 2 people working on the song or on the website, that both authors would be able to exploit the work. And so if that's not what you want, that's not the deal that you have arranged, then you need to specify that again in a contract to make that clear. And it should be in writing, as Catherine was pointing out. Can we go to the next slide? Oh, can you go back to that slide, David, just for a moment? Sorry. That last point, I do want to emphasize that the Copyright Office has a great website, and it is the resource bullet point there. They have a great FAQ situation for you. If you have any questions, it's a great resource for you. And that's also where you have to go if you're going to register a copyright. Okay, next slide then. So here I just quickly mention that copyright does not protect ideas. For example, it does not. J.K. Rowling has the copyright in her books and how they're and what's expressed in her books. She does not own a copyright over stories about teenage wizards that go to school, and so that's the difference there. Next slide, please. So this slide lists some examples of types of works that are protected. I won't go into great detail on this, but this goes back to the point that Amanda mentioned at the beginning of being careful not to infringe someone else's work in the process of creating yours. Like if you're creating a website and you types of works that are protected are pictures and photographs. that you can't just go on the internet and pull a picture off and put it on your website. You may have to license that, go to clip art locations. And so that's just acknowledging other people's ownership in their creative works. The next slide, please. So the protections granted by copyright, unlike trademark, as Amanda was mentioning, a trademark can last until it's abandoned. There's specified periods of time for copyright. It's life of the author plus 70 years. And why I mention that is when that time period passes, the work goes into the public domain and can be freely used. Sometimes there's some confusion over whether or not people say, well, it's in the public domain, and they're saying, well, it's available on Google, or if I do a search that I can get a Google image. But publicly available does not equate to public domain in all likelihood. So you need to check before you use someone's some type of work, music or picture, or whatever you can find on the internet. And a copyright holder holds the exclusive right to reproduce or copy their works, make creative works based on it, distribute copies, and show the work to the public. And so if you perform any of these actions without permission, you could be liable for infringement of copyright. Which is why checking out the copyright registration and licenses is important. And the next slide. So there is a defense to copyright infringement. It's fair use. I'm not going to go into great detail because it's a multi-factor test here. I only mention it to the extent if someone makes a claim that you've infringed their copyright, you may have a fair use defense. If you are making decisions about what's on your website, what music to play somewhere, how to market your works, and what materials to use, don't assume that fair use is going to apply. I would recommend that you get legal advice because it's a very complicated analysis and you need someone to advise you as to whether or not you would have a valid fair use defense. Next slide. So here, copyright notices are no longer required in order to have a copyright. It is suggested that if you are trying, this is part of your business and you are trying to copyright it, that you do make the notice. One, it will, at the end of the day, if you're ever litigating, help you because the person is on notice that it's copyrighted. But also on a more practical level, it provides notice to people that may want to license your work to who they contact to request a license so you can monetize what you created. Then next slide. So just briefly again, the Copyright Office is where you would have to register your work. This is the website that you'd go to do that. There's a wealth of information available there. Copyright registration usually can be handled for a nominal fee. If you expedite it, it's greater. Deposit copies is just that you have to deposit a couple copies of your work. And then last but not least, the Copyright Office is merely a registry. It's not, they don't do anything to verify the originality of the work. So one, it's not going to necessarily validate your registration, but if someone has a registration, it also doesn't mean it can't be challenged. And with that, I'll turn it over to David.
Thanks, Julie. Bria, I know we're over time, so I can, if you think we have a little bit of room here, I can just speak for a few minutes about trade secrets.
Sure thing. I think speaking for a few minutes, and actually, I think we probably shouldn't take questions, but if you do have questions, of course, feel free to apply to Tzedeck or shoot me an email and we can get you help. But sure, David, take just a few minutes.
Okay, so well, trade secrets are a bit of a mystery to a lot of people. They sound really cool, but it's something that a lot of people just don't know about. So if you're one of those people, you're in good company. But a trade secret, and I'm sorry for the build on these slides, and Julie, I had it off at one point and it came back on, and so I didn't want to interrupt, but I think we'll roll with it. So A trade secret, basically, it's covered by federal and state law, and it protects, copyright, which Julie explained, is movies, books, those sorts of things that are recorded or printed, and that are creative. Trademarks we just heard about. Patents are inventions. They have to be new and non-obvious, and there's a whole sort of checklist that you need for a patent. But a patent isn't, you get a patent on an invention, right? A cool new device, a Rubik's Cube, a hook for a hat that hangs off a table, all kinds of things, car parts. Trade secrets really cover information, and it's a really broad definition. And it's any information that, or formula or method or technology that is valuable to you and your business because your competitors don't know it, and you get some benefit from it. But if your competitors knew it, then they could compete with you. And trade secret law, basically, if you keep something confidential and you take reasonable steps to keep this, this information confidential, then it becomes your property, and you can file a lawsuit if someone steals it from you. And that could be a competitor, and usually it's an employee or a former employee that will go and work for a competitor and take a thumb drive or papers, or maybe even what's in his or her head, and go to a competitor and say, hey, this is how my old company did X, Y, and Z. You can do it too. In California, you can't stop, other than a few exceptions, you can't stop an employee from going to work for a competitor after they leave your company. And you can't stop an employee in California from, going, and I'll explain this a bit more, but from basically trying to compete with you, or going to customers who may be yours, or even trying to hire employees that are at your company and taking them away from you. Those are very hard claims in California. But what California does protect very seriously are trade secrets. And so, a trade secret, the best examples are like, recipes, for example. I think the, Coca-Cola formula. Coke doesn't have a patent, but Coke's never published exactly how they make Coke taste like Coke. Pepsi doesn't taste like Coke, and Trader Joe's cola doesn't taste like Coke, and that's a secret. When you get a patent on an invention, you have to make it public. You have to file it, tell everyone how you do it, and if you get accepted, then no one else can do that for like 20 years. With a trade secret, you don't make it public. It's yours. You keep it confidential. You might tell employees it, subject to confidentiality agreements, but if it gets stolen or employee takes it, you'll have a claim against them. So it's really, really valuable. And most business owners don't even realize how many trade secrets they have. Some examples, I have a friend who's starting a skincare line, right? That's very popular now. Creams for the face, suntan lotions, skincare products. Those aren't really copyrighted, right? And they're not inventions per se, but the exact kind of ingredients and formula are trade secrets. And if you make a really, really good skincare product, you want to make sure, and this is the key to trade secrets, that you are keeping that stuff confidential within your small business. So if you have a really famous recipe or a method for making a certain high gloss paint coating for furniture, or something that your competitors can't do that gives you an edge in the marketplace, it's really important that you take steps to keep it secret. Things like, password protected computer systems, making sure that employees don't use their personal devices. If you have to share it with a customer or a client who's not a competitor, that you use non-disclosure agreements. All of those things are necessary, because if you put it out there, then you lose the protection of a trade secret. If you talk about it and brag about it, if Kentucky Fried Chicken starts telling people about, like, the Colonel's secret spice recipe, then it's not going to be a trade secret, and they can't sue an employee or a competitor for stealing that. So keeping stuff confidential is really important. And The most kind of significant thing in this whole area of law that we deal with our clients, and whether it's a big company or a small one, is, you know, technology, right? It's when an employee leaves, making sure that they don't have access to your system or their old email or files, that you have them turn over their papers, you know, their thumb drives and external hard drives, and that you have a process for doing that. That's the number one way that trade secrets get out. And teaching your employees about them, and also having, for really confidential stuff, having only those who need to know it be told what those trade secrets are. And sometimes, you know, customer lists can be a trade secret if, you know, your list of customers aren't known to the world. Sometimes it's details about particular customers that you've built up over time. It could be like Apple, which launches, you know, new products every year. What Apple is developing and planning to launch is a closely guarded trade secret, because they don't want, you know, Google or Samsung or all these other companies to launch a competing product. So those kinds of strategies can be trade secrets, and the list is limitless. So, you know, I think that, you know, things to keep in mind are having control over your technology, your computer systems, employees who need to know it, those who don't. Understanding kind of that your employees should have non-disclosure agreements, and that if you have to share some of your info with a vendor, that they sign non-disclosure agreements. All of that is going to be critical to protecting your trade secrets, and also giving you protection in California over your business from unfair competition, especially where you can't stop employees from competing against you after they leave and go to a competitor. So I know that was a really condensed version, but we're on a tight schedule, and I don't want to keep you know, some of the people who are having consultations with us waiting. So I'm going to pass that back to you, Bria. Hopefully that gave people a feel for trade secrets. Thanks.